confirming, Madam Speaker, that we are seeing your screen.
Yes, you definitely are. I'm just trying to get the slideshow to play.
Okay, there you go. Yes.
Thank you for that introduction, distinguished Toastmaster Nakira Simonet. Good afternoon, my fellow Toastmasters and guests. As distinguished Toastmaster Nakira Simonet would have stated, my name is Ms. Rhodreka Strachan, and I am here presenting under the topic, Will You Get Yourself in Check? So firstly, we actually want to establish or define what is a will. A will is defined as a written declaration in a manner prescribed by statute, entailing the intention of the testator with regard to matters which he or she wishes to take effect upon death. In essence, a will is a document that must comply with the statutory requirements and exemplify the testator's intention as well as take effect upon his death. A testator is a person who executes a valid will. A will includes any testamentary instrument of which a probate may be granted, for example, a codicil. A will, in essence, dictates what ought to be done with the estate as at the death of the testator and confers benefits accordingly. A will is ambulatory, meaning the will takes effect upon the death of the testator. A will can be revoked at any time before the death of the testator unless there is a loss of testamentary capacity. Why create a will? You should create a will because it saves time, money, and stress for your loved one. Intestacy can get very complex, and whenever the court has to actually determine who should function as the administrator. You should also create a will because determining who should get what out of your assets can become very contentious between family members. You should create a will to determine who will manage your estate. The will basically wraps up all of your affairs, from closing accounts to liquidated assets, and even appointing someone as an executor that you can trust. You should create a will because you are able to decide who gets what of your assets. You're able to name specifically who is entitled to what. You can also name them as beneficiaries. You can appoint a guardian for a minor child or a special needs adult. A will permits you to make charitable donations to civic organizations. Characteristics of a standard will. The Wills Act of the Bahamas specifies that the will is to be in writing, and it also specifies how it is to be executed. The will is to be executed, and it must be apparent from the face of the will. The statutory requirements of a will are that the will must be in writing. It must be signed by the testator or some other person in his presence and under his direction. It must appear to the testator by his signature intended to give effect to the will. The signature must be made or acknowledged in the presence of two or more witnesses present at the same time. These witnesses that are selected to sign the will must be capable of giving evidence in court. Each witness must either attest or sign the will or acknowledge his signature in the presence of a testator, but not necessarily in the presence of another witness. Requirements for a valid will. In order for a will to be valid at the time of making, the testator must have attained the age of 18. He must have complied with the statutory formalities outlined in the Wills Act, and he must be animus testandi. This simply means that he must possess the testamentary capacity to create that will. Testamentary capacity. This is an essential requirement for the creation of a will. This basically refers to the testator having a mental capacity. The law requires that for the testator to be deemed to have capacity to make a will, the testator must be of sound disposing mind, memory, and understanding when he or she gives instructions, and also at the time when he or she is to execute the will. The law or the common law has been strategically designed to establish a test in order to determine whether a testator has testamentary capacity. The test outlined in common law has three tiers. One, ensure that the testator understands the effect of his wishes being carried out after death. This simply means that he understands the nature and characteristics of an actual will. 2, the testator must understand the extent of the property which he is disposing. This simply means he must understand what he owns or has owned and is disposing under the will. 3, the testator must understand the nature of the claims on him. The testator must understand who he is writing out of the will. For example, if one of my fellow Toastmasters or guests have a son or a daughter, and they draft a will, and they have written that son or daughter out of the will, they're not estranged to the son or the daughter, we must determine or be certain that this testator has willingly and intentionally written this possible beneficiary out of the will. Alterations to the will. Just like any other document, a will can actually be altered. A will can be altered because the testator may change his mind or make certain changes before he actually executes the will. A testator may also decide that he wants to make some changes after executing his will. In order for a testator to make these alterations before the execution of the will, he may actually just wish to alter it. However, it is to be noted that where the alteration is to be made after the will has been executed, there are statutory provisions that must be followed. Alterations made before the execution of the will are fine. They're regarded as merely alterations. However, if an alteration is made after the execution of a will, there are specific formalities outlined in the statutes that must be followed. These formalities include that the testator as well as the witness's signature must be next to the alteration at the end of the will or at the foot of the will. Types of clauses contained in wills. There is no specific law that outlines what exactly persons should include in their wills. These here are examples of the types of clauses that persons can include in their wills. A revocation clause. Now, this clause simply revokes any previous will or testamentary document that the testator may have executed prior to this will. Clauses appointing executors. This is simply the testator appointing a person or an individual that they can trust, that they are certain will execute their wishes. Clauses appointing guardians. Clauses can be included in the will that allow persons to appoint guardians for children as well as special needs adults that are dependent upon them. Clauses gifting personal property. This can be items including cars, jewelry, diamonds, plates. It can be anything of that nature. Clauses relative to pecuniary legacies. This is simply clauses relative to gifting money to beneficiaries. Payment of debt accrued by the testators. The testator could possibly have a debt that they would have accrued prior to their death that they would wish to be paid based on whatever the value of their estate is. Clauses gifting real property, and this refers to gifts of land. Donations to nonprofit organizations, churches, or foundations. Foundations or organizations such as the Red Cross Fair, Toastmasters, Rhodreka, anything along that line, as well as annuities to be paid to specific beneficiaries, which are yearly payments to be paid to beneficiaries. Now, these clauses outlined at 1 to 9 are simply examples. There is no law that speaks specifically to what can or cannot be gifted under a will. A grant of probate. The grant of probate will be given to the executor that is named in the will. The grant of probate is an order of the court issued under seal of the court to an executor or executors of a testator. The grant is obtained by the process of the executor making an application lodging certain documents in the probate registry. The original will and other probate forms will be lodged with the probate registry, which will allow the applicant to establish that the will was duly executed, as well as establish the contents of the will. Succession and intestacy. Upon death, within the Bahamas, where there is no real and personal estate of the deceased, where there is no will, the real and personal estate of the deceased will be distributed based on the rules of intestacy. A person is said to have died intestate, being without a will, when the deceased never made a will where the deceased made a will, but he lacks capacity or there's a defective execution, where the deceased made a will, but it was revoked, the deceased made a will which he attempted but wholly failed to dispose of any property, or whether the deceased made a will which contains no disposition of his property. Entitlements on intestacy. When a person dies intestate, the rules of intestacy have created a chain of distribution to assist in administering the estate of the deceased. The chain of distribution specifies which persons are entitled to a share of the deceased estate by law. These persons would be required to prove their relation to the deceased. Their relation can be proven through the use of birth certificates, marriage certificates, or even adoption certificates. The chain of distribution. Now, as I stated, this chain of distribution is based solely on the rules of intestacy. The deceased has died. If they died leaving a surviving spouse with no children, the surviving spouse would receive 100% of the deceased estate. If the deceased has died with a surviving spouse and children, the estate of the deceased will be divided into equal shares, 50-50. If the deceased died leaving no spouse, only children, their estate will be distributed amongst the children equally. If the deceased children are now dead and they have grandchildren that are alive, the estate of the deceased will be distributed equally amongst the grandchildren of the deceased. If the deceased have no grandchildren and their parents are alive, their estate will be divided equally between their parents. If the deceased parents are deceased and they have brothers and sisters that are alive, their estate will be divided equally between their brothers and sisters. If the deceased brothers and sisters are no longer alive, their nieces and nephews will receive their estate in equal shares. If the deceased nieces and nephews are no longer alive, their grandparents will receive the estate of the deceased in equal shares. If the grandparents of the deceased are no longer alive, the uncles and aunts of the deceased will receive the estate in equal shares. If there are no uncles and aunts that are alive, the children of the uncles and aunts will receive the estate in equal shares. After we've already cleared off all of the persons on the chain of distribution, if all of these persons are deceased or do not wish to retrieve anything from the estate of the deceased, it will be passed to the next of kin, who will be the surviving living relative or the closest person to the deceased. Grants of letters of administration. A grant of letters of administration is an order from the court on the seal which confirms or confers the authority of the personal representative to administer the estate. The grant of letters of administration sets out the terms under which the estate is to be administered. One distinction must be highlighted between a grant of letters of administration and a grant of probate. The grant of probate, where there is a valid will. The authority of an executor to appoint by will dates from the death of the testator, but an administrator in a grant of representation has no authority prior to the grant of letters of administration. Conclusively, a will is a testamentary instrument that can be beneficial to both you, your interested beneficiaries, and your intended beneficiaries and your family members. The will empowers you and ensures that your wishes are carried out upon your death. Although it is wise to execute a will, the law within the Bahamas makes special provision for persons that may have died without a valid will. Fellow Toastmasters and guests, thank you for your time, and that completes my presentation before you this afternoon.
Thank you very much, Madam Strachan, for a very thorough and detailed presentation. Fellow Toastmasters and guests, Ms. Strachan has been kind enough also to indulge us in a few minutes of Q&A. And we're just past 7:30, so I will open the floor for any questions for Ms. Strachan. And Ms. Strachan, while people may be thinking, maybe I can kick it off just by asking the question around the cost for engaging a legal service provider to prepare a will.
Well, I can speak for BRS Chambers. For wills that are not complex or where there are minimum assets, it can range from anywhere from $350 to $500. However, the more complex it gets, or the price would increase, and we would go based on an hourly rate. However, as complex as it may get or it may seem, complex referring to the amount of assets that the person may have who wishes to make the will, it'll likely be under $1,000 to draft that document on your behalf.
Thank you. Questions, Toastmasters and guests?
Toastmaster Strachan.
Yes, Toastmaster Miller.
We've all heard in a valid will. And there have been instances, and I'm sure at some point all of us have heard or know someone who will has been contested. My question is, can a valid will be contested by any family member that is not in the will? Or anyone, I should say, that's not in the will, especially a family member?
Thank you for your question, Toastmaster Allison Miller. By law, no. However, we have heard in the past of persons that are not in the will that may be that may wish for it to become contentious, or that may feel like they have been disentitled to that will. Like I would have stated during the presentation, the grant of probate is by court order. Whoever is named as the executor is required by court to carry out exactly what is contained in that will. So even though persons may attempt for it to become contentious, the court order is basically for the executor to carry out those wishes of the deceased.
Thank you.
Any further questions? Table topic.
Go ahead, Chanel. Go ahead,
Yes.
Chanel.
Yeah, I have a clarifying question. So you showed a slide with the distribution line, and I'm wondering if someone passes away and they don't have a will, is that the order that's followed?
Correct. If someone passes away, okay, if someone dies and they don't have a will, by law, they are considered to be dead intestate. Intestate meaning they haven't executed a valid will and they have real and personal property that can be distributed. Now, the law makes provision for these persons to ensure that their assets are just not existing or their assets just wear away. That chain of distribution ensures that persons that are relatives to the deceased receive a portion of their estate. And in looking at that chain of distribution, these persons are required by law to prove their connection with the deceased. They have to present a birth certificate of their grandmother connecting them to the mother, or anything along that line connecting them. So it's not, I think this is my sister and maybe she's my sister, I'm not sure, but I want to get into her estate. No, you have to actually go to the court with cogent evidence, documentary evidence, proving that she is a relative, he or she is a relative.
And a follow-up question to that. So if a will is written, but a will is written and it doesn't follow that distribution order, based on that situation, is it possible for a family member to contest the will, or is it just that the will is written the way it's written and there's no way to contest it?
Okay, so that chain of distribution that I showed you, that's in instances where there is no will. Where there is no will, then we refer to the chain of distribution. Now, where there is a valid will, whatever is in the will is what happens. Like I said, the ground of probate is court ordered. So the executor is required to do everything that is contained in that will once the court, the probate registry, grants the order relative to that. That chain of distribution is only in instances where there is no valid will.
I have a question for you, Toastmaster Strachan. A friend of mine, she and her former husband were in the process of a divorce. And when she checked first, the divorce had not been finalized. He passed away. She has a child. Out of that marriage, there is a son. Now, the family of the deceased is really giving her a hard time in terms of getting any funds for the child. But of course, she's not to the point whereby she can actually, financially afford a lawyer. Are there lawyers that would take something like that as pro bono in terms of seeking some kind of retribution for the child?
Thank you for your question, Toastmaster Foster. In instances where there is a divorce in place and the divorce has not been finalized, meaning the decree nisi has not been made absolute, there is no official divorce, she is still by law his lawful wife. So she is still entitled to the estate. And the fact that you said there is a child that she would have had with him out of wedlock, or where is the child with someone else, or how?
No, it's during the marriage.
Right. So that child is also entitled to a portion of the estate. She is still his wife by law, one, because no decree nisi has been made absolute, if I'm going based on the facts that you would have told me, as well as the child, being his child, is also entitled to a portion of the estate. So they would fall first in line based on the chain of distribution, as opposed to any of his other family members that may think they are so entitled. And further, if the child is under the age of 18, she, by law, would hold the child's portion of the estate on trust until the child attains the age of 18. So they are first in line. Now, relative to pro bono, there are firms that would actually take matters of this nature pro bono. However, it is something that would actually be discussed over a consultation or over an official meeting, because you need to know all of the facts and all of the nuances that are attached to the actual probate. So before there is any official agreement to there being a pro bono relationship, you would need to know all of the facts as well as the nuances and whether an official decision is to be made, whether it can be treated as a pro bono matter.
Thank you.
Thank you very much for the questions, Toastmasters. This is the final opportunity for questions. Are there any final questions? There being none, Ms. Strachan, officially, this concludes your presentation this evening on Will You Get Yourself in Check? Thank you so much again for your informative and detailed presentation. I will ask that you kindly share your contact information with me so that I can share it with the VPE for further circulation amongst our members. Thank you once again very much.